Public lewdness. What is this? What is the crime? Can the state of Texas prove the crime of public lewdness beyond a reasonable doubt? Today, I want to talk about the crime of public lewdness. What's required to be proven? Are there some legal defenses that you could use if you were a loved one or facing a public lewdness charge in Texas? I'm Jeff Hampton with the Fulgham Law Firm. I want to thank you for joining us here today and welcome to our YouTube channel. And by the way, if you wait around to the end of this video, I will also give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Okay, so let's jump into this. And listen, this is kind of one of these weird crimes. Everybody knows what they are. It applies a lot. We get a lot of these for juvenile cases as well as young adults that essentially it's sexual activity that takes place in a public environment of some sort. And it's not always what you think it is. But we need to analyze this because it's not some sort of deviant sexual activity. This is two consenting adults having sex, but the problem is, are they being reckless about where they're doing it? So let's see what the law says and what has to be defined. Because remember, if you or a loved one are facing this crime, you don't have to prove anything. The state of Texas has to prove everything beyond a reasonable doubt. So under Texas Penal Code Section 21.07, the district attorney's office must prove the following elements of public lewdness beyond a reasonable doubt. A person commits the criminal offense of public lewdness if he knowingly, that word knowingly, engages in any of the following acts in public place, or if not in a public place, he is reckless about whether another is present who will be offended or alarmed by, and I could go over a bunch of these, but the main one is sexual activity, some type of sex act, whether it's actual sexual intercourse or any other type of sexual activity where there's some type of exposing of genitalia or whatever. You know what that is. So one of the things that we see is the most common fact scenario is someone is arrested for this when there are two people that just go parking somewhere and they decide they're going to mess around and do some things in their vehicle. Or maybe they decide they're going to do something in an area that someone could see them, but may or may not be in a public place. We see this happen in public parks sometimes. We see it happen on private property, but in an area where someone else could see what's taking place. So let's first identify what is the definition of public place for a public lewdness charge. Texas law is specific, stating that public place is defined as any place to which the public or a substantial group of the public has access and is included but is not limited to streets, highways, common areas of schools, hospitals, apartment houses, office buildings, transport facilities, and shops. For example, we had a situation where we had a client call us and asked us, they said, hey, listen, my girlfriend and I, we had sexual activity in our car in the apartment complex parking lot. It's private property, so it's not a big deal, right? I mean, it was owned by the apartment complex and not by the public in any regard, so I should be able to do that. Well, be careful. A public place is not necessarily defined by who owns it. Public place is defined by whether or not a substantial group of the public could have access to it. And an apartment complex parking lot is one of those places defined by law, okay? Now, what about reckless? What does reckless mean for public lewdness in Texas? In order to be convicted of the crime of public lewdness, remember, the prosecutor must prove that you engaged in sexual activity in a place that you were reckless about whether another person would be present who might be offended or alarmed by that sexual activity. So Texas law defines recklessness as, quote, disregarding a substantial and unjustifiable risk that the result will occur. So in plain language, recklessness means you recognize that there was a substantial risk that your behavior in some way could put someone in a place where they'd be alarmed or offended. You recognized it, but you just disregarded it and decided to do it anyway. For example, there are differences on this. If someone has a vehicle, and let's say it's a truck, and there are two people having sexual intercourse in the bed of that truck, there's any reasonable person, and understand the standard here is whether a reasonable person would know that there is a substantial risk someone would see or be offended by this. In that situation, a reasonable person is going to believe that someone would see it or be offended, particularly if there's other cars around, particularly if it's near where other people might be. Okay, so that's an example of that. Let's talk about a few legal defenses. As you can see from the criminal elements that we defined in Texas Penal Code section 21.07, whether the acts were committed in a public place and whether someone acted recklessly are two areas that must be thoroughly investigated. And so the sexual activity was not in a public place can be one of the areas that your attorney needs to look into thoroughly. For example, we represented a client that was charged with public lewdness because there was sexual activity taking place in a tent on a parcel of public land in a park. The difference is and you say public land, but it was kind of remote. It was out there in the middle of nowhere. It was taking place late at night. No one else was around except for the police officer, right? And it was most of the tent was closed off. It wasn't exactly something that was exposed for other people to see. Now, the question would be whether or not that behavior was reckless in that situation. Our argument was that it was not, that a reasonable person would believe that there was not really a substantial risk that someone else would be alarmed or offended by this because it was in an enclosed area and it was not just sex in public. That's not what was going on here. And I know this is an odd topic to talk about here, but there are many times if a police officer rolls up on someone, seeing someone doing anything sexual in nature, they're going to immediately look to arrest them for the crime of public lewdness. It's not that simple. They're going to have to prove that you acted reckless in your activity. And so would a reasonable person believe in that example I gave you that someone would have been able to see what was going on and be offended by it? Our argument was no. And it was successful for that particular client to make sure that they did not have the charge of public lewdness on their criminal record. Now, the other thing is, what if two people were doing something, but there was no actual sexual activity that took place? Right? This happens sometimes when someone rolls up on someone seeing the mirrors or the actual car's all fogged up, right? And it's warm going on in the car, but there was a lot of kissing and other things going on, but no actual sexual activity as defined by the code. And the question becomes, what did the witnesses claim to see? Are they able to actually say that they observed sexual activity going on? And if not, it's important to understand if those witnesses are not 100% clear on that the state of Texas may not be able to meet their burden of proof and the case may be subject to a dismissal. And so in those types of situations, that's why we don't just accept whatever the police report says. Your criminal defense attorney needs to look into that thoroughly and make sure and expose those weaknesses in the state's case, okay? Now, finally, what are the criminal consequences for a public lewdness conviction? If you are charged with the crime of public lewdness, it is a Class A misdemeanor, punishable by up to 1 year in the county jail and up to a $4,000 fine. Here's the thing. I know it sounds like it's such just really not that big of a deal. The problem is if you are convicted of the crime of public lewdness, in addition to fines, penalties, probation, court costs, this can carry a very negative stigma. Many employers and other people that see a public lewdness charge think there's some type of sexual deviancy going on. They don't even know what it means. It just sounds bad. Lewdness does not sound good. So people jump to conclusions. That's why, particularly if you're a first-time offender, it is critical that you work with an attorney to make sure that you are able to stay out of jail, avoid a conviction, and get this off of your criminal record. And that can be done in many ways. If the state can't prove the case, they need to dismiss it. Even if they can prove the case, but it's a first-time offense, sometimes you can get a conditional dismissal, or by all means, you need to take your case to a jury trial if you have an unreasonable prosecutor working the case. Now, I hope this has been some of assistance to you just to give you a general overview of your legal defenses and what the state of Texas must prove on a public lewdness charge. And if you are facing you or a loved one are facing a public lewdness charge in the North Texas area, I want to invite you to have a free consultation and case analysis with the Fulgham Law Firm. You see this number that's above me right now. Feel free to give it a call. We'll give you a free consultation. And I hope this has been some help to you. I promised you a free ebook at the end of this video, what to do if you've been charged with a crime in Texas. All you have to do is click down into the YouTube notes below, into the notes section. Click into that, send us over your email address. We'll send that free ebook over to you. And if you liked what you heard today, subscribe to our YouTube channel. We'll send you more great content just like this. Thanks for joining us. We'll see you next time on our YouTube channel.